There's an expression that sunlight is the greatest disinfectant. Well, now that Jussie Smollett's motion to dismiss the lawsuit has itself been dismissed, and this matter is normally going to go to trial, they had better settle quickly,
or this case is going to get a whole lot of sunshine.
Viva Frei, Montreal litigator turned YouTuber, and Jussie Smollett is back in the news, this time with his motion to dismiss itself being dismissed. Am I making you nauseous? Oh! For those of you who are new to the channel, I have been covering the Jussie Smollett saga since March 2019. This case alone has been a crash course in US law. Now, for those of you who don't know me, I am a Montreal litigator turned YouTuber, although I'm still a lawyer, but I make YouTube videos called vlogs, like a play on the word vlogs about law vlogs. I have done 8 separate vlogs on this subject, documenting all the developments from beginning to present. Now, for the 7 or 8 of you who are unaware of what's going on, in January 2019, Jussie Smollett alleged that he was a victim of a racist and homophobic hate crime. He told Chicago police that he was assaulted sometime around 2 a.m., I believe, on a cold winter night by 2 people wearing Make America Great hats. He alleged that his assailants physically assaulted him, poured liquid on him, and tied a noose around his neck. It turns out that allegedly he faked the entire hate crime by paying 2 of his friends, the Osundaro brothers, money to perpetrate the attack against him. And this lawsuit has gone through so many twists and turns, it has taught us a lot about the American legal system. The first important thing that this entire legal saga has taught us about the American legal system is something called pretrial diversion programs. For those of you who don't know, all of the charges against Jussie Smollett were abruptly dropped, and nobody could understand how it happened. And that was the first vlog I did on the subject, explaining how and why the charges could have possibly been dropped against Jussie Smollett, at least in law. Now, here's a clip from my vlog on the subject explaining how it was that the charges were dropped. You'll have to forgive the tacky sunglasses and awful music in the background. I was doing vlogs a little differently then than I am now, but let's just flash to that clip right now. In criminal law, there is something called a pretrial intervention or a pretrial diversion, depending on your state or jurisdiction. What this means is it's sort of a non-criminal resolution to a first-time non-violent infraction. It typically applies to misdemeanors, which are not serious crimes, or non-violent felonies. And so it seems that all that happened in this case is that the prosecuting attorney decided that Jussie Smollett, for his first-time accusation of a non-violent felony of disorderly conduct, was eligible for this program, and that justice would be better served by seizing his $10,000 bond, 2 days community service, as opposed to proceeding to a trial. I then did a follow-up vlog explaining how a great many people could probably rightly perceive this to be, if not corruption, at the very least What are the dogs doing? What are you guys doing? I'm doing a vlog, people, come on! Oh boy. They do this all the time, they'll figure it out, don't worry about it. Ow! The prosecuting attorneys had already decided that Smollett was gonna go free, and they just needed to find a legal basis to justify the conclusion to which they had already come. Some people are going to look at this and call it corruption, and you cannot blame them. Others are going to look at this and call it preferential treatment, and you cannot blame them. Others are going to look at it and call it unfair and unequal application of the laws, and you cannot disagree with them.
2 months later,
the city of Chicago turns around and sues Jussie Smollett for over $130,000 to recoup the cost of the investigation that they incurred on the basis of the false statements made by Jussie Smollett to the Chicago police. And I did a vlog on that lawsuit, breaking down and explaining the city of Chicago's lawsuit against Jussie Smollett, going through the relevant allegations in that motion. What does Chicago Police Department do? They sue for over $130,000 in overtime salary paid in the context of the investigation surrounding this entire hoax. And now let's get into the lawsuit, shall we? Complaint. Plaintiff, the City of Chicago, brings this complaint under the city's false statement ordinance and the city's cost recovery ordinance against defendant Jussie Smollett, seeking relief against defendant for false statements he made to the city and seeking recovery of the costs of necessary services provided by the city due to defendant's violations of the MCC, and in support alleges as follows. And so what happens after the City of Chicago files suit against Jussie Smollett? Jussie Smollett's attorneys make a motion for change of jurisdiction to the federal courts, and I made a vlog explaining all of the strategic reasons why they would have wanted to change from state to federal court. Jussie Smollett, through his attorneys, has filed a motion for transfer of jurisdiction to the federal courts. Why would Jussie Smollett's attorneys want to have the case moved from state court to federal court? One of the potential explanations that I read that makes quite a bit of sense is that the federal juries have a much broader geographic range than state juries. Apparently, federal rules of procedure are potentially more favorable to the defendant than state rules. One of the other justifications that I read was that federal courts tend to be a little bit more lenient in granting motions to dismiss. And after the prosecuting attorney Kim Foxx graciously bestowed this pretrial diversion program on Jussie Smollett, he came out nonetheless maintaining his innocence. Not only did he maintain his innocence, but his attorneys took to the public stage to reiterate the fact that the Osundairo brothers were in fact the perpetrators of this racist and homophobic hate crime. And that very aggressive offensive that Jussie Smollett's attorneys went on actually led to the Osundairo brothers suing Jussie Smollett's attorneys for defamation. And I did a vlog on that subject, delving into the question as to whether or not someone can sue someone else's attorneys for defamation, because it is in fact a very interesting question in law. After all the charges are dropped against Jussie Smollett, he and his lawyers take to the offensive, reaffirming that he was in fact the victim of a racist and homophobic hate crime, suggesting that the Osundairo brothers were actually dressed in whiteface when they perpetrated this crime against Jussie Smollett. The Osundairo brothers file a civil lawsuit for defamation, not against Jussie Smollett,
but against his attorneys.
Generally speaking, lawyers are granted pretty much absolute immunity for acts they carry out for and on behalf of their clients. And can you imagine a world in which lawyers would get sued for defamation for representing their clients who may say things about the opposing party that may turn out to be false? You would live in a world where lawyers would never represent any client for fear of facing a lawsuit for defamation for having said things for and on behalf of their client against their adversary. And apparently the lawsuit was in fact transferred to the federal court, and what happens after the lawsuit was transferred? Jussie Smollett's attorneys file a motion to dismiss for failure to state a claim, and I did a vlog breaking down that motion to dismiss and the response from the Chicago Police Department. How's that for a good deep breath? In early August, Jussie Smollett's attorneys filed a motion to dismiss, and the city of Chicago filed a response to the motion to dismiss, and they are fascinating to read, so let's just get right to the vlog. Defendant's memorandum in support of his motion to dismiss plaintiff's complaint under Federal Rules of Civil Procedure 12.6b. The Rule 12.6b, motion to dismiss for failure to state a claim, means what exactly? To survive a Rule 12.6b motion, the complaint must allege, quote, enough facts to state a claim for relief that is plausible on its face. So they're arguing sort of that the city is attempting to recover costs on the basis of an allegedly false statement, when the criminal charges brought against the accused on the basis of that allegedly false statement were dropped by the prosecuting attorneys.
This perverse tactic is entirely at odds with the form, function, and prior use of the FSO and CRO.
Can it justify a motion to dismiss at a preliminary stage? Absolutely not in my mind, but I have been wrong in the past and I'll be wrong again in the future. Well, this time I was actually right. This morning, U.S. District Judge Virginia Kendall in fact dismissed Jussie Smollett's motion to dismiss. Now, as at the time of making this video, I don't have my hands on a copy of a written judgment, if there is in fact a written judgment. Now, from the news articles that I've been reading, it seems that the judgment was rendered orally because the articles are reporting that the judge, quote, said as opposed to wrote. And it wouldn't be unheard of that a judge renders their decision orally and then produces a written judgment later. Although it does also happen that a judge will dismiss a motion from the bench and then issue a PV, procès verbal, or the minutes of the judgment at a later date, basically just summarizing what happened, whereas one party made a motion, whereas the other party contested it, whereas the judge is not convinced by the arguments, therefore dismisses the motion. And from the practice of law, we know that when a judge issues their judgment from the bench and then follows it up with the procès verbal or the minutes, it's generally a good indication as to how they felt about the motion that they just rendered a judgment on. And it also relates to the nature of the judgment that they are rendering. If it's a very serious judgment with very serious consequences, the judge will be sure to have a very well-drafted written judgment. For example, if the judge were going to grant the motion to dismiss and dismiss the city of Chicago's lawsuit, sure as sugar there would be a very well-drafted written judgment because there's a high chance that it would go to appeal. There's a high chance that it would go to appeal because the judgment would basically have the effect of doing something that could not be undone by final judgment because there would be no final judgment because the motion would have been dismissed. Whereas there's ultimately minimal consequence to dismissing the motion to dismiss because a judge on the merits can still dismiss the motion if it is ill-founded in fact or in law. And it's typically the exact same thing when it comes to judgments on admissibility of evidence. If there's an objection to the production of evidence and the judge says, I'm going to overrule that objection and allow the evidence to be produced, there's not really going to be a written judgment because there's nothing being done that can't be undone by final judgment. The judge on the merits can determine that the evidence is irrelevant and not consider it. Conversely, if the judge grants an objection to the production of evidence, that's something that can't be undone by final judgment because the evidence will never find its way to the judge on the merits. And so if a judge maintains an objection to the production of evidence and deprives a party from producing something into evidence, there will most likely be a written decision explaining why that occurred, just in case the party so deprived of adducing that evidence wants to take that decision to appeal. Alright, so back to Jussie Smollett and what happened. Well, this is another situation of the mainstream media just repeating and regurgitating the same headline and one-line summary over and over and over again. Judge denies motion to dismiss Chicago lawsuit against Empire actor. Typo. A judge denied a motion to dismiss the City of Chicago's lawsuit against actor Jussie Smollett at a hearing Tuesday. Judge allows Chicago's suit against Jussie Smollett to proceed. A federal judge has refused to dismiss Chicago's lawsuit against former Empire actor Jussie Smollett. Federal judge refuses to toss out Chicago's lawsuit against Jussie Smollett. A federal judge has denied a request from former Empire star Jussie Smollett to dismiss the City of Chicago's lawsuit against him, meaning the city may proceed with its push to reclaim $130,000 it says the police department spent investigating the actor's allegedly false claims. Not being in possession of any written judgment to the extent that one exists or will exist, the best news I could find on the subject actually came from a couple of tweets from someone named Jason Meisner. Just in, a federal judge just ruled the City of Chicago's lawsuit can go forward against Jussie Smollett, seeking reimbursement from the former Empire actor for police overtime in the investigation of his allegedly staged attack in January. In denying the motion to dismiss, Judge Virginia Kendall said, "It isn't unreasonable to think Chicago police would have vigorously investigated Jussie Smollett's report of a racist and homophobic attack, particularly given his celebrity and the volatile climate we are in." And that is what leads me to believe that the judge rendered the decision orally, possibly with the minutes to follow, but probably not with any lengthy written decision justifying the dismissal of the motion to dismiss. And if you have seen my previous vlogs on the subject, you will recall that Jussie Smollett's motion to dismiss was a multifaceted motion to dismiss. One of the arguments was that the city could not claim its investigation costs under the false statement ordinance because the charges against Jussie Smollett were dropped and therefore it was never proven that his statements were false. One of the other arguments, and it's a creative one for which you actually have to give the attorneys some credit, is that even if Jussie Smollett's statements were in fact false, nobody forced the city of Chicago to incur that much overtime in investigating Jussie Smollett's claim. I know that some of you are going to laugh at this argument, others of you are going to be shocked at it, but there is something of an argument in law, and it's called actus novus. If there is something of an intervening act that sort of absolves one party of their responsibility, the argument would be that nobody compelled the city of Chicago to do what they did. They did it of their own volition, and so if they did in fact go overboard, they can't turn around and claim that overboard costs from Jussie Smollett. And one of the other arguments, also creative, is that the city was making its claim both under the false statements ordinance and the cost recovery ordinance, and therefore was double claiming amounts from Jussie Smollett, and as such,
Their lawsuit should be dismissed?
and my immediate reflex was maybe that's a good argument to reduce the amount claimed, but it can't possibly serve as the basis of a motion to dismiss. In any event, the judge obviously did not retain any of the arguments put forward by Jussie Smollett's attorneys. And in her judgment, the judge rightly concluded that it wasn't unreasonable to think the city of Chicago would do what it did, given the complaint made by Jussie Smollett, given his celebrity status, given the political climate in which we live. And while the judge is not making any determination on the allegations or arguments on the merits, this matter is going to proceed to trial and possibly proceed to trial as early as 2020. One thing that is very interesting from the court filings, I was able to obtain a copy of this thanks to help from my lawyer friend in Dakota, Stuart Hughes, thank you very much. The parties have until November 1st, and I'm quoting, "to inform the court if they are requesting a referral to the magistrate judge for the purposes of a settlement conference." And what is a settlement conference? Well, it's exactly what it sounds like, but in some jurisdictions, you can actually have a judge sit in on a settlement conference. You can have a judge sort of direct the settlement conference. Basically, the parties notify the court that they are open to having a settlement conference presided by a judge. That judge, at the very least in Quebec, and I suspect it's the same elsewhere, cannot be the judge who then hears the trial on the merits, but that judge sits in on a settlement conference, sort of directs the parties, tries to jostle a settlement between the two parties. And the courts that offer this type of program typically promote it very heavily because it's a little known fact, but something like 90% of all lawsuits that are ever filed never get to judgment. My prediction is that this lawsuit is going to settle sooner or later, but it is going to settle. It might even settle with Jussie Smollett paying the entire amount. And here is a very interesting fact as well. If Jussie Smollett pays the entire amount, it ends the lawsuit. There will be no trial, there will be no discovery, there will be no judgment on the merits. There will just be someone paying off the amount claimed to settle the dispute. Jussie Smollett might even pay the amount claimed plus interest plus legal fees simply to avoid the discovery process and a trial on the merits. That is my prediction. I don't know exactly how this matter is going to settle, but this matter is going to settle and probably settle before discovery. All right, and that is the latest in the Jussie Smollett saga. I will be adding this video to the Jussie Smollett playlist, which you'll find right here. And if you like my content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, and share my channel. I appreciate it greatly. If you want some merch, link is in the comment section below. If you want to support the channel, PayPal link here, PayPal link down there, and now you know your vlog. Peace out. Booyah!